Hey everyone, Harry here to talk about the very important, hot off the presses opinion on presidential immunity in a case involving Donald Trump from the DC Circuit. All right, this is spanking new as of this morning. It's 3 different opinions and 67 pages. So I've read it quickly, and I'm going to stumble ahead to give you the main contours. And if I'm wrong in certain particulars, forgive me. I wanted to prioritize speed here over perfection. So first, big development. Very importantly, this is the case by civil plaintiffs. This is not a criminal case. It's by 2 officers who were injured January 6th and sued Trump. However, the immunity that Trump claimed is of a piece, identical to, separated by that much with the immunity he has claimed and is now being litigated at the trial level for the January 6th case. He said essentially the same thing. And this is the court that sits over the district court in DC, where that case is being tried, and below the Supreme Court. So it's more than it casts a shadow. It really, for now, states the law on presidential immunity and rejects Trump's claim. So, in addition, it's from an ideologically diverse panel, including a conservative Trump appointee who concurs, and it kind of spans the DC circuit. Maybe there's one now uber conservative that Trump appointed, but otherwise it seems to me this will speak foremost on the court. I don't see a lot of agitation to now bring this court wide, etc. And so this lays down the law, as it were, in a way that I think will hold. All right, what is the law? The law under this opinion is that Trump's claim that the January 6th speech is protected by presidential immunity fails. And the main reason it fails is that there is a maybe not clean, an important distinction between acting as a political candidate or as the head of a party. In other words, trying to get yourself or anyone elected versus actually doing the duties of the presidency. So it's an objective test, says the court. It's not what was in the president's mind. Was he thinking as a candidate, or was he thinking as a official president? Because, as the court points out, that is A, very intrusive on the president, a subjective test, but also B, very murky. Almost always the president's mind partakes of both. So how do you know that a particular act is as a candidate or head of the party as opposed to an official act? A big factor is the context in which it's made, objectively speaking. So the court points to a difference between, on the one hand, the State of the Union address versus a political rally. The State of the Union will almost always be an official act, and a political rally will not quite always be a private capacity, not in as president act. When I say not always, the court is at pains to say, look, let's say a president uses a political rally to do something like firing a secretary of state. That would be considered, he's acting as president now as an official act. That would be cloaked with immunity. How does it cut in this very case? Well, importantly, this case is at the complaint stage. This is a little legal, but I think you guys mainly know it by now. You file a complaint at a civil stage, and the other side comes in and moves to dismiss the complaint before it's been litigated. That's what Trump did here. Trump said, doesn't matter what the facts show, I am immune. And it's in this setting that the DC Circuit says, no, you're not. However, the facts haven't been developed yet. Now they will be. That's a multi-year process. This case is now going into the sort of ether, and we won't be following it, but this is the most important part, where they'll actually be talking about Trump will make his best case on the facts that actually he was acting in his official capacity on the ellipse. But given the line that the court has drawn, it seems very, very hard claim for him to make. And he, as the court emphasizes, bears the burden to show immunity. So here he is on the ellipse saying we won't have a country anymore if Mike Pence doesn't do the right thing, et cetera, et cetera. Is that Donald Trump, president of the United States, or is that Donald Trump, political candidate trying to win? You know, I think the facts, if those say went to a jury to decide, would overwhelmingly be that he's in the second category, and therefore that he is not immune. So it seems to me to point very strongly toward a resolution on the facts and the objective standard of immunity, of no immunity where the January 6th case, speech and all the activity and the inaction as Rome is burning, as the melee is going on, all that stuff, I think, really looks like it won't be immune when all plays out. All right, now let's transpose it to the very more important context of the January 6th trial. Point one, there is now before Judge Chutkan a similar motion saying, I get immunity. It's a pretrial motion. Trump is saying, dismiss this complaint. I am immune. And we've always seen this. I've always seen this as the least frivolous or the most potentially serious of the pretrial motions Trump has made. Chutkan so far hasn't ruled on that motion. You can expect her to do it now. And assuming she rules against him, you can expect it to go to the DC Circuit now, the very court that's just decided this. And you can expect the DC Circuit to decide it along these lines. I will get to the Supreme Court shortly. At a minimum, it seems like the claims having to do with January 6th themselves, obstruction of an official proceeding, etc., shouldn't be covered by immunity under this standard. Now, recall that the criminal complaint doesn't start January 6th. It goes back. What about these meetings that on the one hand, he's, got his White House counsel there and they're trying to, figure things out. On the other, it's plainly him trying to hold on to office, acting as a candidate. That might be tougher calls that Chutkan in the first instance and then the DC Circuit would make. But at a minimum, this claim, it seems to me, the criminal complaint survives in large part, even if some of it has to be trimmed, altered, set to the side for now. So this is half the reason why I say up front, big development. Now let's talk about timing. So the DC Circuit panel has ruled what could happen next. Two things. Either it could go en banc to the full DC Circuit, and in addition, it could go to the Supreme Court. In terms of the en banc circuit, it's an ideologically diverse panel. They've made a pretty clean ruling with that all three of the judges agree on. I'm trying to think who would really agitate for on-bank review and successfully agitate. There's this one new Trump appointee, but I just don't see it getting purchased, meaning Trump has the ability and will exercise it to move for on-bank review, but I don't think he'll get it. What about the U.S. Supreme Court? Well, in addition to their overall reasons for not wanting to parachute into the middle of this issue, they have an additional one, which is as the DC Circuit made clear, we don't have the full facts yet. They've just remanded this civil case back to the district court to develop. And that's normally a reason why the Supreme Court would say we are going to pause until we have a full factual record. They certainly can, if they want, get involved. We could see a couple votes or 2 or 3, and that will be a real sort of prefiguring of what will happen to this issue eventually, that is to say, in the criminal case. So there's some drama to play out there, but I don't see it likely, if I'm handicapping, and obviously I'm throwing a lot at you guys and at myself, but if I'm handicapping, I don't see the Supreme Court taking up this issue. Again, it's all on the civil track of the civil case now. So focused on what happens back in Judge Chutkan's case, assuming she issues immunity quickly, it now goes up to the DC Circuit. And I think it's likely to affirm, at least in large part. And then that would be the case that the Supreme Court could potentially reach down for, but it would be inserting itself into the middle of a presidential election, would be Bush v. Gore like. We'll see the setting if and when that happens, but it would be less than a 50% shot if you're trying to handicap these very murky, but also very consequential events. Last thing, the opinions themselves. You have the chief judge of the DC Circuit saying basically drawing the line I said, the difference between acting as not a potential, of course, as a candidate or the head of a party on the one hand, versus the official president on the other, the announcement that it's an objective test, the determination that this is just for now on the complaint, and it has to await the actual full facts to see how it applies. That's the chief judge's opinion. And then comes the Trump appointee opinion that basically reaffirms these most important points, the ones that I just said. Judge Katsas, it seems to me, has signaled he is not going to quibble with the proposition that Trump isn't immune. And then the third judge simply emphasizing that this is at the motion to dismiss stage. We need more facts. And as a result, there are sections of the court's opinion joined by the chief judge and Judge Katsas that she doesn't join. But all in all, basically a home run for the plaintiffs and a huge loss for Team Trump. This is the most important legal issue to determine both the criminal liability and the timing of the determination of criminal liability for Trump. So this is the party not before the court, who's the biggest winner today, Jack Smith, or you could say the American people. It's a giant step in the direction of holding Trump accountable for the January 6th conduct and rejecting the claim of his immunity. And then secondarily, it's, timing is tricky because of even DC Circuit and Supreme Court denial of review takes some time. The Supreme Court, a wild card, all true, but definitely a big development in favor of a quicker rather than slower disposition of the criminal trial, the January 6th criminal trial, now more likely than yesterday to go forward in ample time before the November 2024 election. So a ton of stuff from this opinion. Again, it's fresh off the presses, and I'm giving you the very quick take, but I think it holds up. And this will be one when, history books write about the whole brouhaha. There'll be at least a line for this when the DC Circuit said no immunity. It's at the DC Circuit level, but of a piece with Nixon versus Fitzgerald, United States versus Nixon, important cases in the Nixon era rejecting that president's claim for immunity. Bad day for Donald Trump, good day for Jack Smith, good day for the American people. Talk to you later, and I'll be talking to you plenty about this later. The repercussions of this will be playing out for months. So there you have it, hot off the presses and more to come. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.